evidence of this nature is ordinarily dealt with. How it plays itself out in a court environment. That's all I'm debating.
We're in the same place. I'm not in the V-raise.
So the voluntariness, compulsion, and so on does not arise in that context.
Agreed. I was just saying that those are the important context issues which need
I've not forgotten
to be considered.
I've not forgotten
I'm indebted. So the point that I would make regarding that process that Chair posits to me about rebuttal witnesses and contrasting experts, and Chair says is in the ordinary course, that's what I was saying at a bit earlier about less intrusive means about the available to the Commission. If the doctor's evidence, which Mr. Carrim's doctor's evidence, which relies on his objectivity, is in dispute. And that's the basis through which it can be impugned as a less intrusive means without taking us into a V-raise problem about is this voluntary examination voluntary or not voluntary. So I would respectfully say that what Chair has posited to me is the exact thing that the doctor has been tendering, and I think, in fact, in correspondence, Mr. Carrim's own attorney said, let's do it this way so that you can get the degree of satisfaction that you require. Now, I understand, Chair, to say that, that might be how it's ordinarily done in the High Court and maybe it's different in the Commission or whatever. All I'm saying is that's a process that's available, and if my learned friend contends that there's prejudice suffered as a result of the lateness of the report, whatever unfolds as a result, now that they have the report and their possession will unfold, and we'll deal with it as we need to deal with it. But the fact that the mechanism is available, which we on behalf of Mr. Carrim proactively offered, and Chair himself now recognizes as a possible mechanism. I'm not saying Chair says it's right or correct or good or whatever. I'm just saying it's in the realm of possibility.
Which mechanism? Are you talking about the doctor?
The rebuttal witness mechanism that Chair started talking about. I'm saying that the fact that that mechanism exists in the possibility of options in next steps as a less intrusive means is as far as I'll take it. The fact that there are ways to obtain the Commission's own assessment about objectivity or otherwise
that assessment
without the medical examination.
No. I was talking pursuant to a medical examination.
But you remember
that's what Mr. Carrim, through his doctor, is resisting. So I don't get you.
No. Remember, I said that was a contextual issue, that the voluntary exam is voluntary, and then Chair responded and said, but we're not there because that's a virus issue and we're not talking about that.
There can't be a rebuttal witness in the sense I was talking about if there has not been an assessment by that doctor.
And that's where I said I respectfully disagreed with that. Remember, that's the first thing I said, is I disagreed with that characterization at the beginning.
I just wanted to make sure, that because it seems you misunderstood me.
I didn't misunderstand.
I was talking rebuttal after an assessment by that rebutting doctor.
And I immediately responded and said, I'm not sure I agree with you in that regard.
Can you move on to your next point?
No, that's fine.
Please?
I was just setting out then the basis for my disagreement with you, Chair, respectfully, about how that mechanism is going to work. I don't have to take it further.
We can't force him. We agreed, and which is why I'm talking about the criminal process that the Commission is minded
Exactly
to.
the point, Chair.
Yes.
Exactly the point, Chair. So that is available. May I just then speak to what the Commission says is the way forward? Chair, you'll remember that in its letter, I'm going to read from page 119 of the correspondence bundle, but as far back as the 24th of June 2026, this is the Commission's letter to my attorneys. At paragraph 12 is exactly what the Commission says today is the way forward, obviating the need for a medical exam.
Evidence leaders, Mr.
Evidence
Premhid,
leader,
don't
I apologize.
Don't confuse what the evidence leaders say with what the Commission.
I apologize. The evidence leaders, and I don't want it to sound like I'm
They
now
say
personalizing
in the circumstances, the evidence leaders will proceed as follows.
Yes. So, and that was, you'll remember that was on the 24th of June, and then I think we were in front of you And then there was an exchange of correspondence, and this medical exam issue arose after this letter. But in response to that particular letter at paragraph 12, came our letter, which starts at page 121, which says, yes, if that's what you want to do, that's what you must do. And so insofar as Ms. Hassam says today, the evidence leader says today, that this is the position of the commission and we'll...
Of the evidence.
Of the evidence, this is the position of the evidence leaders. We understood that to always be the case from that page previously, and we've never taken objection to that, which is why, Chair, you'll remember in that debate that we had, I think, that the transcript refers to, when you and I were discussing the adverse findings that were to be made, my response to you was that, yes, that's the ordinary way in which evidence will be dealt with, and if it's unanswered, you'll draw the appropriate inference, you'll draw the appropriate credibility finding, and that's the risk that my client was always subjected to, and that's the consequence he must face. So if that's the Commission's attitude today, consistent with what they previously said on the 24th of June, in that debate with you, Chair, you'd remember I said I can't commit my client to a position, but I explicitly said to you I could not fault that that's the end point we'd come to. So to the extent that's the evidence leader's, Commissioner Kamalo, to the extent that's the evidence leader's position in front of you today, I accept that position. In fact, and not to be flippant about it, we were already here a month and a half ago, and only as a result of the Commission's extension and the possibility of a medical exam did all of these issues arise all over again. So in fact, we're now going back to the position that we were in late June, and with all due respect, the Commission, but also sometimes the evidence leaders complain that the Commission is running out of time and there's no guarantee of an extension. So we're back to where we were on the 24th of June, the Commission and or evidence leaders do, and we'll deal with the consequences. Lastly, Chair, on the issue of the possible recommendation of criminal sanction, whilst you've got that the letter I referred you to starting at 121 in front of you, it's just a few pages on from the Commission's letter at paragraph 12 that we were dealing with. If you could please go to paginated page
124.
124, yes indeed. That's the request.
Again, Commissioner Kumalo.
Thank you, Chair. I'm indebted. Particularly paragraph 11. If such a recommendation is going to be made, then on that specific question about whether criminal charges should be recommended or not recommended, all I'll say is that our client, as far back as the 24th of June, asked that if such a referral was going or recommendation was going to be made, that he be given the chance to address specifically that referral decision, consistent with authorities like Dupria and so on, and also because that's an Audi issue, we say respectfully, and particularly to place in doubt the question of willfulness and whether or not such criminal charge is competent and viable as against my client. However...
aren't those issues, that is the issues of willfulness and so on, issues that should actually arise before the relevant criminal authorities? If that referral does not get killed at the level of SAPS or at the level of the NPA, they may then be dealt with by the criminal court. So I'm not sure I get your point.
What I was going to say, and then rightfully I showed deference to the Chair, is that on that particular point, about Audi in front of you before the recommendation, I was going to say that's not the hill I'm going to die on, because it might be correct that you can make the recommendation being recommendatory in nature without ticking the box of direct external legal effect as well as adverse consequence that you even owe us the right of Audi at that stage, because the correct decision-making functionary is where we'd have the ability to make those representations anyway. So what I was going to say to Chair is that the request is in front of you. You may choose to say no, which is fine. I'm just saying that the request is there. That's all I
We
have to
are
say.
all here now. Make whatever submissions you have in mind in this regard, so that we are done, it's done and over with.
Thank you, Chair. May I just make 3 submissions in this, in this regard then? Number one, the test would be willfulness for any such breach or non-compliance. We say that the threshold is not met, having regard to the medical evidence that is in front of you, and which is unchallenged, and I know that that's sensitive territory, so I tread lightly. That's the first point. The second point is that the point about that evidence being unchallenged, so to speak, and where non-compliance is as a result of medical advice as a valid and legitimate excuse is actually something recognized by the foreign authorities that my learned friend Ms. Hassan handed up at the last hearing. You'll remember I was going to do an audit of those authorities, and then Chair intervened and said, no, maybe we can leave those authorities, and we did, and I never went on to those authorities. But can I just give you the single reference to the one authority, please, that is in my learned friend's bundle, and I just want to point it out because I say that that's the second basis upon which we're entitled to utilize that as a valid excuse for non-participation. And if Chair will just bear with me, I now need to find my own papers. Yes, it's the authority of Wandsworth. The full citation is Tainaz versus Wandsworth, square bracket 2002. It's the England and Wales, I think it might be Court of Appeal, EWCA. No, it's the Administrative Court, I apologize. EWCA Civil Division 1040. At the bundle that was given to you by my learned friends, you'll please look at paragraph 21, where the conclusion reached by the court in that regard is that where a litigant was unable to attend through no fault of his own must usually be accommodated, however inconvenient, and then goes on to say it would be absurd to criticize a litigant for not attending to give evidence on his condition when the doctor has advised him that on medical grounds he should not attend. That's at paragraph 25 of that same authority, and in the paginated bundle you'll find it between paginated pages 31 and 33 of that bundle. So that's the second reason, Chair, that there's authority to say that there is a valid exculpatory reason which has been given. And the third one, Chair, is to say that, and I don't want to rehearse this argument, is that rather than recommendation which is a punitive, and I use this word guardedly, but which is potentially punitive to obtain a particular outcome, is he well or is he not well, as on the back of not complying or not attending, there are less intrusive means available, and that a criminal recommendation in the circumstances is the most extreme option available, and that the Commission can still, and if the Commission does that, and I hope I'm using Commission in the right sense now, Commissioner Khumalo, if the Commission does that, it almost brings that line of inquiry to an end because it passes it over to a different functionary. But that if the Commission and the evidence leaders was interested in continuing this line of inquiry to establish what is or is not the case, then less intrusive means are available. So at a broad level, those would be the tenor of our submission, subject to specifics, but I appreciate the Chair's affording me an opportunity to highlight that all the same.
Two related issues. One is laying a charge a recommendation in the sense in which you've referred to. and 2 is laying a criminal charge, something that would implicate the Audi rights at all. This is just laying a criminal charge. And ordinarily, the Audi rights would be implicated in a situation, or would arise in a situation where a decision is taken. I know you'll say, well, laying a criminal charge is preceded by a decision to lay the criminal charge. I'm happy that you are shaking your head and that you are not going to say that. I'm happy to hear that. So, 1 is laying a criminal charge, a recommendation in the sense in which you use that word, and 2 is laying a charge, or does laying a charge implicate Audi rights at all?
Why I shake my head is because I think it depends on the underlying conduct. So if there's a recommendation for the preferment of charges, so in other words, you, Chair, in your capacity as Chair, write to the SAPS, whoever the relevant police station would be, and say, we recommend that you open a case for an offence of the Commissions Act, then I would say that is where the territory is of Audi because of the recommend.
I don't see why the letter would say a recommendation is being made. Someone would just go to a charge office or write to the police and say, a charge of ABCD is being laid. So that's laying a charge. It's not recommending that a charge. And then it's for SAPS to investigate or look at the information given and then saying, because of the authorities that Mr. Premhid referred to, there is no case whatsoever here, and therefore they refuse they do not even take that docket to the NPA.
No, that's why I'm saying it depends on the underlying conduct. If you are the complainant going to the, and I say you, I mean obviously ex officio in your capacity as the chair, or the secretary perhaps, because I understand that the secretary is the hand through which a lot of the operations of the commission unfold. So I'm going to refer to the secretary. If the secretary is herself, in her ex officio capacity, the complainant at the police station, then that's why I was saying it depends on the form of the conduct. Then I don't think I could have an Audi objection, because that's as good as, and now I'm going to abuse Ms. Matlingwane's name next to me, that's as good as if I went to the police station and laid a charge against Ms. Matlingwane for intimidation, which is probably coming very soon. She's a very good junior. But I don't owe her a right of Audi. I accept that. That's why I was saying, however, if the secretary is going to write to the SAPS to say, I am recommending that you SAPS charge Ms. Matlingwane with intimidation, and that flows from an ex officio capacity.
Let me right away say, if what I said the commission is minded to do does eventuate, it will not take the form of a recommendation. The commission will just lay a charge.
Yes,
so I think we should just step off this idea of a recommendation.
No, correct.
And let's move on.
Yes,
on
because
that will not eventuate.
Yes, because that also takes me to my original point, which was to say this might not even be the hill for me to die on, because it might be appropriate that any such Audi right is not given effect to in front of you, per se, but then in front of either the SAPS or the DPP or whomever, as you ordinarily have the right to make representations to the DPP. We are disagreeing with each other. I was only responding to the question Chair posited to me, which was what's the difference and what are the consequences between a recommendation per se and the laying of a charge, and I was trying to engage with
how the Audi rights get implicated.
Yes. But because Chair has now said to me that if it is to eventuate, it's not going to take the form of a recommendation, the Audi issue is irrelevant, with all due respect, because I think we've come to a consensus that if there's an Audi in the context of the laying of the charge, that must happen elsewhere, not in front of you. But
I'm sure we are agreed that you've made all your submissions.
Yes,
in
yes,
this regard.
absolutely.
So
In
that
fact-
you don't say, but Chair, you said, are Audi rights implicated at all? And I, that is you.
No, no.
And I said, not if it's not a recommendation.
Correct.
You made your submissions
absolutely.
on the Audi points and whatever other rights
No,
in this regard, and you even came to the point that we are done with our submissions.
in
on this.
fact-
I just want to make sure
In
that.
fact, Chair, you've been so generous to me. Before any decision to recommend or lay a charge has been made, you've invited me to make those submissions in the first place. So,
Yes.
so I am very,
you did.
and I did, and I'm very indebted to you for that opportunity, and indeed to respond to what my learned friend said, considering that I was very short in opening. And I'm indebted for that. In fact, we've taken far more time than I would have hoped for, and I apologize for that if that's my doing. So, but I'm indebted to you, Chair. May I just take an instruction?
And Commissioner Baloyi has a question.
Oh, I apologize.
Yes. No problem.
Thank you. Mr. Premhid, is it not simply this? We are sitting here where Mr. Carrim has not appeared, contrary to a ruling that he must appear today. And that ruling had behind it that he would be excused if we get an independent medical report that says he's not good to testify. We're sitting in a place where we don't have that medical report, and therefore there's no basis for us to say he is properly excused not to be here. Aren't we sitting with, there is no satisfactory explanation, therefore, for his non-appearance? And then, because our rules do deal with such matters, if a witness is required to appear and they do not provide a satisfactory explanation, certain consequences would follow. Isn't it simply that we're sitting where we do not have a satisfactory explanation because of the issues that you have been ventilating with the chair, but the bottom line of it is that which was prescribed as a basis to excuse him has not been complied with. Therefore, we do not have a satisfactory explanation, and we must deal with it in accordance with our rules. Is it not that simple, really?
Well, I think the danger in characterizing it as being that simple, Commissioner Baloyi, with all due respect, is that then elevates the modality, which is voluntary, but let's leave that to one side, the voluntary of the examination and the excuse to being a prescriptive basis to exclude any otherwise valid excuse. So on your narrow reading, if I understand correctly, Commissioner Baloyi, I can't disagree with you. And the reason I can't disagree with you is because, of course, in terms of what the order specified, non-compliance has arisen. But what I'm saying is I don't know that that would be, and I'm choosing my words carefully, I would question the competency of such a directive in circumstances where it's applied prescriptively in that way, and where non-compliance is potentially dealt with punitively